Senate Standing Committee on Economic Development, Tourism, Labor. I welcome you all this morning. Thanks for being here. If you do have a cell phone, I ask that you please turn that to silence or vibrate as we conduct our business here today. As you see, we do not yet have a quorum. We're running into an issue when we have the education meeting at 11 o'clock, and 5 of our members on this committee are members of the Education Committee. So I do apologize. Some will be trickling in as we conduct our business, but I do want to at least go ahead and get started this morning. If you would like to sign up for a bill to speak for or against, I ask that you please sign the sign-in sheet at the entrance of the room. The request to speak is within the chair's discretion based upon the time constraints that we have in here today. Also a reminder, there's no signs permitted in the meeting room. And if a member has any questions or comments, please signal to Sasha or to Janine for their attention. Sasha, if you would, go ahead and please call the roll.
Senator Boswell.
Aye. Here.
Senator Funky Fromeyer.
Present.
Senator Gardler.
Aye, here too.
Senator Harper Angel. Senator Howell. Senator Mills. Senator Storm. Senator Thomas. Senator Wilson. Vice Chair Wheeler.
Here.
Chairman Watt.
Present. Go ahead and get started with today's business. I do want to apologize to the Senate sponsor of Senate Bill 15. We did have that on the agenda for last week. However, as I mentioned, I was not able to be here with having a bill in the Education Committee. Some of our members were also present for Veterans Day, for Kids Day at the Capitol with military families, and so we did not have a quorum last week. Senator Westerfield, you are first on my agenda for today. I'm going to go ahead and let you get started this morning, if you would, please, with Senate Bill 15. Identify yourself for the record, please, and then we'll move on with the sub to adopt.
Chairman, thank you. No apologies necessary. We all know how the schedule gets a little dicey up here. And there's a lot of people and a lot of demands on our time. So I appreciate you making time this week in the committee meeting. Members, thank you all for your attention. I brought this bill up for the second year in a row, and I've been working on it even before I filed it last year. Kentucky doesn't have any law in place that provides any protections or rights for consumers in the digital space. Except we exist in the digital space increasingly every day. We rely on it, all of us, in some form or fashion. Even if we're not trying to, we end up relying on that system of the digital world, and we don't have any protections there. We don't have any rights there that I think we ought to be able to have. The data economy is worth a lot, trillions of dollars. It's important for it to exist. I don't want to stop it. I do want consumers to have a voice in it because today they don't have one at all. We have 2 laws in the books in Kentucky that handle the digital world in any way, and they are related to data breaches, both for the public and the private sector. And those have been around for the better part of a decade, I'd say. But there's nothing else. There's nothing else to protect us or give us any rights to our data, and it's our data to start with. We share it. We are generating that value in that data economy. Senate Bill 15 sets out to create those protections. It's only materially only about 11 sections long. It's got 14 or 15 sections in it. Section 1 covers the definition. 2, there are a slew of exemptions. I'm not aiming to create another layer of compliance on top of something else that already exists. If you already have to comply with HIPAA, we're carving you out. If you've got some sort of other federal requirements you've got to deal with, we're carving you out. I think, and there are about 5 other states that have a bill like this that have been enacted. I started with the Virginia bill and improved upon it. I believe my bill has more exceptions and carve-outs than anybody else's in any other state. Again, I'm not trying to double up. I just want to provide protections that don't currently exist. And then Section 3, and that's the key area, that's where the rights themselves are listed. In Section 3 of the bill, it creates an appeal process. So if you've tried to exercise one of these rights with a company and they deny it, you can appeal that. It requires that appeal process. Ultimately, the company still has the final say because there's no appeal beyond that at all. But we'll get to the private right of action in just a moment. Section 4 covers the duty of the controller. The controller is the company that you're dealing with as a consumer that has and is collecting that data. They may process it themselves. They may hire another party to process that. But the controller is that company that you've got the responsibility with, or that relationship with, rather. It also calls in Section 4 a report. And I should have clarified, you have proposed Senate Sub 3 that's before you that makes an important change in this particular section.
Senator Westerville, really quick, we do have a quorum now. Senator Howells came in. I do want to acknowledge that. So
Thank
we
you.
do have constantly do business. So with that, do I have a motion to accept the sub on Senate Bill 15?
I make a second.
Motion and a second for both members. All those in favor of accepting the sub do so by saying aye.
Aye.
All those opposed, motion carries. Senator Westerville.
Members, thank you, Chairman. I appreciate that. Section 4 makes an important change there. Originally, it was a quarterly report to more than just the Office of the Attorney General. It's now an annual report to the Office of the Attorney General. Section 5 controls or governs the duty of the processors involved. Section 6 governs de-identified data. That's data that has been stripped away of anything that can identify or trace it back to who you are, being the consumer there. Section 7 deals with controller powers and some protections for those controllers. There are some limitations on what this bill requires a controller to do, and some exemptions and protections for those businesses that have to comply with this bill. Section 8 calls for the data protection impact assessment. This is a basic list of basic information that any company that wants to get involved in the data space and monetize that information in some way, if they're acting responsibly, should be able to answer every one of those questions and identify that information with ease. They're not accustomed to compiling it right now, but again, the information is not novel to them if they've taken any responsible due diligence to get into the data game at all with their business. Section 9 governs the OAG investigation powers. It gives the Office of the Attorney General the power to investigate issues and claims that are brought up by consumers. And then Section 10 is unique in the country. There are two things about my bill that are different from most of the other states. The first one, way back in Section 2 or 3, now that I can't remember which one it's in, I don't have the bill in front of me, pulled up anyway, sets a threshold above which this bill even applies. Most of the other states have a threshold of 100,000 customers. The laws in those other states don't kick in until you've got 100,000 customers or more. Y'all, that's an unconscionably high number of customers for them to finally have to abide by some sort of law. 99,999 customers is a lot of customers. And I think the threshold should be 1. I've told every advocate that opposes the bill or that supports the bill that the threshold should be 1. I can't pass 1. And last year at 10,000, I got substantial pushback. I have made it 25,000 in this bill. It should be 1, but I'm happy to give 24,000 things up. So that's the threshold. The other issue of contention, the biggest I'd say, is the private right of action. This is unique in the country. Now I realize that we generally speaking, the collective we, sometimes frown on creating private rights of action. There's concern among some about creating an opportunity to take people to court, frivolous lawsuits and the like. But our Constitution establishes the courts for the redress of our grievances. Now, I don't want to create, with apologies to Senator Wheeler, a trial bar bonanza on one end, and I don't want to create the alternative, which is what most states have done, and that's pure OAG enforcement. And the reason behind that, folks, is this. No matter who sits in the office of the Attorney General, be they Republican or Democrat, it does not matter. They will make a political calculation about whether or not to take a case. They'll also consider the resources and staff and the scope of the damage, but at some point, they're going to decide some number of Kentuckians complaining about business X is not enough for us to warrant going after it. And so the only thing that's left in the states that have OAG enforcement, you file a complaint online. We've got a consumer protection statute framework in Kentucky right now. It's been around for many years. And you file a complaint online. No human that I'm aware of touches that letter. The computer spits out a form letter. It goes to the company you complained about. You fix this, company. And then what happens after that? That's what will happen with pure OAG enforcement. So I tried to find something in the middle. My bill is a hybrid of both. I heard input from a group that opposes the bill last year. They talked about a report from the Office of the Attorney General in California where they have a private right of action but only for data breaches. And they said, look, our OAG enforcement mechanism works pretty well. It cures the problem 70% of the time. And setting aside my suspicion that an AG's office would ever put out a report saying that their thing doesn't work very well, Let's just assume that it does. Let's assume that that's true. So I've deferred and delayed my private right of action in this bill until after you've filed a complaint with the OAG, that form letter goes out, and they still don't respond. I've limited the private right of action in a second way. It is for injunctive relief only. You can't get money damages. You can't sue them for money. You can't sue them to get rich. The lawyer can't get rich. The plaintiff can't get rich. You can only ask for injunctive relief. And then I limited it, and this is a change importantly in the sub that you've adopted. My intent was only to be able to enforce the rights created in the bill, and now it explicitly says that. One of the opponents raised the concern, well, you could file a lawsuit to shut our whole business down. You cannot. You can file this lawsuit at your own expense because you're not going to get some trial attorney or whatever. You're going to have to pay for that. You can't get rich off of this claim. But you can only ask the court to enforce the 6 rights provided in Section 3. Rights like a right to a copy of your data, a right to delete your data, a right to opt out of targeted advertising. Lord knows we all want that. A right to opt out of tracking, which is when a site or a business follows you from one company to the next company online, which happens every day. I'm not giving you all the slide deck I've shared with this committee before, so for the new folks, you haven't seen it. I've shared it with Senator Funky Fromeyer in our office meeting one-on-one, but that's happening. When you load the homepage of the Courier-Journal, and this was 4 or 5 years ago in 2018 or 2019 when I captured the screen grab, but there are 4 dozen companies who are loading code on the homepage of the Courier-Journal. Now, some we'd recognize that load the right font so the Courier looks like it's supposed to look like when you load the homepage. Google Analytics, so they know the traffic's going up or down. But and you all know this, I've said this informally, and you all recognize it, I'm the biggest nerd up here. There are companies I still don't know the names of. And no one visiting the homepage gives consent to any of that. There's value in some of that, but we ought to have a say. I think we carry a lot of water for businesses, and we should. But this is a place where we need to carry water for consumers. I ask for your support of the bill.
Thank you, Senator Westerfield. We do have, before any questions specifically to Senator Westerfield. Senator Frankie Fomar.
I just wanted to acknowledge my appreciation for your nerdiness, Senator Westerfield, and the fact that you gave me 2 weeks to look this over, because it really truly has the value for consumers. And I'm a small business owner, so I do recognize that businesses may be affected. But I believe, as you do, that maybe one consumer having the opportunity to opt out, but we gave it 25,000 as kind of that number. But thank you for bringing this forward. Very complex, very meaningful, and in fact, straightforward. It's actually simple. Thanks.
We are getting the sign-in sheet for anybody who has signed up in opposition. I do want to make reference. Judy Taylor has put a letter in members' folders. I always make sure that members do know things that were placed in their folders that were requests from that. And I will find if we have anyone that has signed up in opposition. Okay.
Chairman, I should have mentioned, and I can distribute this to the members, but Consumer Reports has supported the bill, and they've got a letter, and I can share with the chair and the members.
Thank you. Only one I have signed up I see is Kate Shanks and Shannon Stiglitz representing the Kentucky Chamber and also the Kentucky Retail Federation. If those two individuals would just make their way to the table, please. They did sign up to wish to speak against the bill, so if they would make their way. Kate and Shannon, you know the routine. If you would, just please identify yourselves for the record, please, and you may proceed.
Kate Shanks, Senior Vice President, Public Affairs, Kentucky Chamber of Commerce.
Shannon Stiglitz, Senior Vice President of Government Affairs for the Kentucky Retail Federation.
Thank you both. Whoever wishes to proceed may go ahead.
I'll go first.
Okay, well, I was going to volunteer, but... By all means.
Chairman, thank you for the opportunity to speak on Senate Bill 15 today. Usually I'm in front of this committee supporting legislation dealing with workforce issues or talking about our tax code. And I'm not thrilled to be here today talking about concerns about Chairman Westerfield's bill on Senate Bill 15. I just want to start by saying we greatly appreciate his interest and really passion for this issue. I think everybody knows that he's a legislator in the General Assembly that's really diving into these issues and cares about these issues deeply. And we also appreciate his willingness to meet with us, discuss the issue, work through some of our concerns. And so I'd just like to lay out a few of those today. This is actually not my first time speaking on the business community's perspective on data privacy laws. I testified a few years ago in an interim joint committee, and at the time, our position was simple. We needed a federal approach to data privacy laws, and that the state-by-state approach, that patchwork approach, could be very costly for businesses as each individual state takes on this issue. And there's been some studies. The Information Technology and Innovation Foundation put the cost of a 50-state-by-state patchwork in the billions on what it would cost for businesses to handle that. But a national framework has not come to be, and we aren't close to a national framework on data privacy. I'll acknowledge that. But while the state-by-state approach is not ideal, it does give us examples of what works and what doesn't work in other states. And it can also give us sort of the next best thing to a federal approach, which are state-by-state laws that are very, very similar. And we have seen legislation passed in Virginia, and other states have adopted that bills similar to that: Utah, Colorado, Connecticut. We understand there's several states working on similar legislation this year as well. And so it's like we're seeing a lot of these states kind of come together on similar legislation. And what that does for businesses across these states is that they're used to the definitions, they're used to the requirements, they understand the enforcement, the compliance piece of it, and it simplifies something that is otherwise very, very complex. Senate Bill 15, though, if passed, would make Kentucky an outlier among the states. What I have heard from members on this bill is that it's complex and difficult to comply with. There are certain definitions that are unique to this legislation. And because the bill favors what we've seen in some other states like California, we know it can be costly. There was a study done there that put the initial cost for businesses with less than 20 people around $50,000, those businesses with 20 to 50 people around $100,000 for those initial costs of compliance. But cost aside, the other concern that we hear from our members is about the user experience and what the customer is experiencing because of data privacy laws. So obviously businesses care a lot about what their customers and their clients think of how they're accessing their product and their services. And there's a concern about the opt-in provision in the bill. If you need a service or product but must opt in for make decisions immediately about how your data is going to be used, how it might be stored, how it might be used after your transaction, that creates an additional layer of privacy protection for the user to jump through. I think it's important that we are balancing what consumers want with what's workable for the business community, but I think we have to be careful to look at consumers as one thing. We are very diverse, and how we use the internet is going to be different across different types of consumers. And I had a really big discussion on this with my husband last night, and we're on two different sides on this issue. So I'm kind of somebody that comes to the internet, not surprisingly, we're polar opposites. Yeah, I know I meant to text you and be like, I got somebody. Anyways, but we're on different sides of this issue. When I go to the internet, I want to pick up where I left off. I want you to know me. I want you to know what I want. And I want you to say, you bought X. People like you also bought Y. Do you want Y? And it's 20% off with free shipping. I like that experience when I shop online. There's a product I've had my eye on for a while. It's priced too high. I've clicked on it several times. My social media feed puts it in front of me daily. It's on sale 20% off with free shipping. So I'm probably going to buy it. So that's the experience I want. And I'm good with the status quo. My husband, on the other hand, would probably opt out of certain uses of his data, though I kind of question it. But he says he would opt out of some things. So what we're looking for in privacy legislation, I want to make it clear we are not opposed to working on privacy legislation in Kentucky, is an experience for the consumer that allows individuals who may want to opt out of how their data is being used to do so with a privacy statement or a consumer rights statement that's easy to understand, ticks off the boxes, and they can make that decision proactively as they want to without interfering with the experience many of us are used to, who maybe don't want to have to opt in over and over as they use a site. I think that's where we need to do some discussion and have some discussion on this bill. And then additionally, we don't have to take a bill word for word from another state. We can make some tweaks that are specific to Kentucky. But I think the process should be mirrored. And what we have seen in states that have passed similar legislation, bringing together consumer groups, different types of consumers, their perspectives, along with the business community that could help you understand how it's going to look for a consumer once it's implemented, what's workable for the business community. That's a process that's worked in other states, and we can use that process here. Lastly, I will say I'm obviously a consumer who shops online constantly, as many of us are. Even when I shop in stores, I go online first. I value my time, I value efficiency, and I do care about privacy. And there would be times when I would look at a certain site and maybe, for whatever reasons, I don't want my data stored on that site. So there would be instances when I would look at that. But I think we have to find something that balances not only what consumers want and what is workable for businesses, but what ensures the consumer experience is a good one and one where they will continue to come back and get what they need efficiently. So with that, Chairman, thank you for the opportunity to speak on our concerns on this legislation, and we will absolutely continue to work with the sponsor on this bill as it moves forward.
Thank you, Kate. Senator Thomas, I know you had a question. Was it directly to Kate? Okay,
Question for Kate.
please proceed.
Kate, if I want to buy a pizza at Pizza Hut, I don't understand why I would want that information to go to big box clothing store or go to big box hardware store or go to any big box retail. I mean, I don't know why they need to get that information or why I would want that information. And I don't think most people realize that without Senator Westerfield's bill, which I will say I've liked for a long time, and Whitney being who I am, that may work against you.
He'll take it.
Sure will.
I'll
I'll take it. I sure will. It'll work against me. I'll take the support.
But I think there are instances of privacy. I mean, Kate, and I'll use my wife as an example. Okay, I won't use your. If my wife wants to go out and buy some lingerie, I don't know that 1,000 stores need to know that information. I kind of think that's private. I kind of think that's private for her. Okay. And so that's what Senator Westerfield's bill is designed to do. To keep the things that we want private, even though we've become an online shopper, keep those things private. And that's why his bill is much needed in the environment in which we live in today.
Senator, I'll take that more as a comment, maybe than as a question. I will say we have 4 other bills on the agenda. I'm going to switch over to Senator Wheeler that does have a question. I know we have 2 that have signed up remotely, so we need to keep this tight and the train on track.
Just very briefly, and this could either be for Kate or Whitney. Basically, this bill, and I agree with Kate. I mean, sometimes I like to know whether something I want's on sale for 20% off. But Senator Westerfield, nothing in this bill would stop me from opting in to get those offers.
Nothing
correct?
at all. That's the key, and I appreciate her example that they have options.
So if I want to get that information, I
You
can
can
just
do
say,
it.
hey, let me know
You
what's
can
going
do it.
on. Okay. That's what I wanted to know. Thanks.
Shannon, testimony?
And I will be very, very brief. I want to thank Chairman Westerfield because he's met with me numerous times and is probably very sick of me, but he's also taught me a lot of information. I think that, Senator Wheeler, I'm going to address your question. You are correct. We, and Senator Thomas, we want and understand that our consumer data is precious to us. If we aren't protecting our consumers, whether it's, as I say, in analog life or in the digital space, then we aren't going to have those consumers. So yes, we want to do that. But we're afraid, specifically in the example you gave, Senator Wheeler, as Senate Bill 15 is laid out, that the consumer will get opt-in fatigue and not pay attention to what should we really as consumers be opting into and what should we be not opting into. And so how can we find that balance? Additionally, for example, the definition of dark patterns is contained in there, and Senator Westerfield has educated me a lot on dark patterns. I'm now very proud of myself when I defeat them. But the issue that even the Federal Trade Commission is currently debating is what is that distinction and line that one crosses between a dark pattern, which really I look at as in analog life a potentially deceptive practice, arguably. I'm sure my folks are screaming, be quiet, and then what is advertising and marketing? And those are the things that we're trying to work with. And Ms. Shanks is correct. We are operating in a digital space. Our members are wanting to meet the consumer where they are and wanting to provide them with the experience that is positive for them and that assists them in ways to get the products that they want delivered with ease or shop in a store. Senator Thomas, we want all of those options available to the consumer. What our issues really are is trying to manage working with a legislation that pulls some definitions from the European model and a California model, where California has struggled immensely with trying to implement their legislation. And how can we balance that and make it work for the consumer and for the business? Because if it's difficult for our members to implement, it's not going to be successful. And I haven't said that, we really enjoy working with Chairman Westerfield on a whole host of issues and want him to be successful. And we want this to be successful for the customer as well as for the business. And we think there are states that have models.
Thank you, Shannon. Senator Howell, question?
Yes, thank you, Mr. Chairman. I guess I can address this to either one of you, but Ms. Shanks, I heard you say this first. If you had, by the way, I'll speak for all of us, if you had a way to make Congress go ahead and act on things that could help all of us on a timely basis so we didn't have to do ad hoc, we would appreciate your input. So there's been a lot of talk about the model legislation, and a lot of that makes sense to me. But have you reached out to anyone about filing any kind of alternative that is a model bill legislation instead of what Mr. Westerfield said? Because I believe you said that you agreed we needed to do something. Have you gone down that road?
Yeah, we have. There's been legislation filed. I think it was last year there was legislation filed. This year there's some bills that have been filed in the House as well. So, and we are committed to working on this issue. And you're right. When I testified on it, this was before COVID, so it's that long ago. And we were talking about a federal approach. And it didn't happen. And so states are saying, we're not waiting and we're going to pass privacy legislation. So, we're on board with having those conversations and being helpful throughout the process and recognizing this is something that you care about. You care about your data. You care about your constituents' data. I care about my data. I know sometimes I can say, oh, click. We all accept the cookies. But it is an eye-opening process to understand how your data is being used. And Senator Thomas, to your point, I think people have a lot that they probably want to learn about this, right? Some of this stuff is us learning how our data is being used, and some of it I'm very okay with it, and some of it I may not be. And so it's a process as well, and I think it's important that we have privacy policies, consumer protection policies that are easy to understand, that people can navigate so they can make those decisions.
Thank you very much. As I mentioned, we do have two individuals who have signed up on Zoom. That's a chairman's discretion. You caught me in a good day that I'm going to allow that. I'm going to first let Andrew Kingman go. I think he's with the State Privacy and Security Coalition. I'm going to limit this to 3 minutes, please, sir. If you can, I've got a timer here with me. So you're on deck. Please go right now. Go.
Thank you, Mr. Chairman and members of the committee. My name is Andrew Kingman, counsel of the State Privacy and Security Coalition. My background is not only as an advocate, but also as a compliance attorney, helping companies work through various state privacy laws. Our goal regarding this type of comprehensive privacy legislation is to work to find solutions that appropriately balance increased consumer transparency and control over their personal data with operational workability? Can businesses actually understand and implement the law? And while I'm testifying today in opposition to SB 15, my hope is that the stakeholders are willing to continue to address the remaining issues in the bill, and that the sponsors' work to bring this important issue forward is rewarded. Right now, we oppose this legislation because parts of the bill remain extremely confusing from a compliance standpoint. And it's not just about compliance costs or burdens for businesses. When compliance is an issue, it negatively affects consumers as well. And if businesses don't understand what they are required to provide for consumers, consumers will be less informed about the rights and controls that they have over their data. This bill combines elements of the Virginia framework with elements from the California Consumer Privacy Act, with elements from Europe's General Data Protection Regulations, and also with novel elements that do not appear in any other privacy law. And the best analogy I can think of is that all these laws operate as individual puzzles. They have pieces that are unique to these frameworks, and they're not intended to be used with different frameworks. So if you have 4 different puzzles and attempted to make one clear picture that was understandable from the different pieces, you wouldn't be able to do so because those pieces wouldn't fit together. And that is our overarching issue with SB 15 as it stands. SB 15 has many elements of the Virginia framework, but has also imported concepts from these other statutory regimes and inserted novel concepts that are extremely confusing. We do see California as a cautionary tale because the compliance targets have been extremely confusing. They have those confusing standards have led to multiple revisions of that law. And there has yet to be sort of a target that businesses can hit where they know that they're in compliance. The initial compliance costs of that law were estimated to be $55 billion for states doing businesses working in that state, with small businesses of less than 20 employees incurring costs of about $50,000. And that's from the state attorney general's own study of this. In conclusion, I do want to be very clear. We do not oppose strong consumer data privacy protections or new obligations for businesses. The Virginia framework covers the concerns that committee members have expressed today, but the bill in its current form is not a tenable draft with which to move forward. Thank you.
Thank you, Mr. Kingman. Mr. Christopher Marchese, win that choice. 3 minutes.
Thank you, Mr. Chair and Vice Chair Wheeler. My name is Chris Marchese, and I'm testifying against SB 15 today on behalf of NetChoice. We are a trade association based in Washington, D.C., and our members include basically all the usual suspects in the tech space, everyone from Google and Meta to Etsy, eBay, and Pinterest. So first, let me just start by saying that NetChoice, like the others opposing this bill, do support a privacy law, right? We recognize that privacy is incredibly important and that Congress has not been doing its job. We are trying our best to get Congress to move on this. I assure you that we are meeting with our federal representatives weekly to try to get them to act. But in the meantime, we do want to work with states to put forward, privacy legislation that gives consumers the rights that they need to understand what is happening with their data, but that doesn't create a regime like California or Europe, where data is seen as an inherently bad thing to collect and a bad thing to use. And to try to dissuade folks from using it, they put up a bunch of burdensome regulations. So instead of repeating what Mr. Kingman said, I'll instead just raise some First Amendment issues. So NetChoice actually has a lawsuit against the state of California right now, challenging a new privacy law that came out at the end of last year. That law is a little different from this one, but it has the same data privacy impact assessment requirement, as well as some notice and appeal requirements. While these are well-intentioned, they are actually unconstitutional under the First Amendment, because basically what the bill is trying to do is to force a legal obligation on covered entities to create these very burdensome, very intensive data privacy impact assessments that include things like analyzing the risk of data collection. And it's just very hard to have a clear sense of how one would assess risk, because it really does vary based upon the user, him or herself. I mean, just in this conversation alone, we've heard from some folks who are very comfortable with having their data shared, I'm one of those people as well. And then there are other folks who want absolutely nothing about them collected or known on the internet. And so it's difficult to try to have an objective way to measure these things. In addition, the sponsor made an amazing point during his testimony about the fear of politicized AG offices. And this is another concern that NetChoice has too, which is when laws are vague, when laws are burdensome, they create an opportunity for arbitrary enforcement, whether it's through private rights of action or the Attorney General. And here, this bill has this vague standard about,
We have a motion on the bill. Do we have a second? We have a second. Motion by Senator Wheeler. We have a second by Senator Wilson. Sasha, please call the roll.
Senator Boswell.
1 minute, please proceed.
This is a very complicated issue, but one thing I can say for sure. Constituents are being sent a lot of information.
Pull your microphone. Can't hear you.
Consumers are being sent a lot of information that they don't want. I'm going to vote to move this bill along, and I think that we're going to have more debate before it becomes law. Aye.
Thank you.
Senator Funke Fromeyer.
I'm going to vote aye.
Senator Gardler.
I have to rely on my good friend Senator Westerfield, but I do hear what you're saying. I'm voting for Senator Westerfield because I know where his heart's at. I don't like voting for anything that California does, though. And Senator Thomas has nothing to do with you either. So anyway, I vote yes.
Senator Harper Angel. Senator Howell.
Explain my vote, Mr. Chairman.
Please vote for 1 minute.
I'm going to explain my aye vote. I think we need to move this matter forward. I've heard a lot of people talk about all the problems that they foresee with Senator Westerfield's bill, and maybe I slept through this in the last 3 years, but today was the first time that I'd even heard that there was an alternative out there. It seems we're real focused on what this doesn't do. We recognize we need to do something, but no alternative is being done. And I'd rather start with something and try to work toward it rather than sit here in neutral and do nothing. So I'll vote aye.
Senator Mills.
Explain my vote.
1 minute, please proceed.
A vote is a yes vote. I appreciate Senator Westerfield's work and the others that have talked about. I believe we're learning about this subject. We're educating ourselves. I think as it moves along, we'll continue to learn. Look forward to seeing what the final document looks like. So thank you.
Senator Storm. Senator Thomas.
I vote aye.
Thank you.
Senator Wheeler.
Mr. Chairman, explain my aye vote.
Please proceed. 1 minute.
I think that Senator Westerfield has worked very hard on this issue. Clearly, he, I think, understands it more than anybody in our caucus. I'm not going to say that retailers have not expressed some concerns, but to me, I generally err on the side of getting more information, and but that's my choice. And I don't see where this bill blocks my ability to make that choice, just like I usually click to accept the cookies every time I go onto a website so I can do something. So I think that most folks, but there may be websites I go on to that I don't want to make that choice. I mean, if it's a one-time thing, I need a new vacuum cleaner, I may not want to have 50 million new products sent at me. I mean, it just, but I think this does leave the choice in the hands of the consumer while letting the businesses have adequate flexibility. So I'd applaud him for his work.
Senator Wilson.
Aye.
Chairman Wise.
Aye. By a vote of 8-0, the bill carries and moves on as it is amended. I know that Senator Westerfield is one that's going to continue to work with all parties that are in this room. Thank you for doing that. Thank you all for bringing your voices to be heard today. The bill moves on. Senator Westerfield, I'm going to have you keep your seat there if you don't mind. I'm going to ask Mr. John McGarvey if he would make his way to the table as we take up Senate Bill 64, an act relating to the Uniform Commercial Code. Mr. McGarvey, real quickly, if you would just hit your microphone, there's a green button there. I know you've testified in front of the Education Committee before with me, so now we're in a different committee, but the floor is yours, sir.
Yes, sir. I come to you not as a lobbyist or representing a special interest, but as your Uniform Law Commissioner and the legislative liaison between the Uniform Law Commission in Kentucky and, fortunately, chairman of the ULC's Uniform Commercial Code Committee. The Uniform Commercial Code is the nation's primary body of commercial law. Its purpose is to facilitate commerce, and it does that two ways. One, by providing a certainty of outcome in commercial transactions, and two, by providing a uniform body of law between all 53 uniform law jurisdictions. Kentucky, along with its sister Commonwealth, Massachusetts, was the first state to adopt the code, effective July 1, 1960. We've updated it article by article as the economy has changed, as it's become more of a national economy, and now we update it with the 22 amendments to the Uniform Commercial Code to accommodate emerging technologies. One of the things we try to do at the Uniform Law Commission is to draft with what we call durability. You won't find a reference to cryptocurrency. You won't find a reference to blockchain. We try to phrase our legislation in ways that will work with technologies we haven't heard of yet. And we try to draft with medium neutrality. This is the first total not rewrite, because we still keep with the same basic policies of the code. It's the first total update to bring the code into the digital world. We have a new Article 12. If you know the code, you might say, what happened to 10 and 11? Those were transition rules, so they've gone away. Article 12 concerns controllable electronic records. Again, we try to draft with durability. Does it include cryptocurrency? Yes. Does it include a non-fungible token that might be a digital work of art? Yes. But any electronic record that is subject to control. That's a new form of collateral that hasn't existed before the digital economy. We go further than the new article. I'll give you an example. Many of you may be...
Second.
We do have a motion from Senator Mills. We have a second from Senator Wheeler. Do we have any questions before we proceed? Sasha, if you would, please call the roll.
Senator Boswell.
Aye.
Senator Frankie Fromeyer.
Aye.
Senator Girdler.
Aye.
Senator Harper Angel. Senator Howell.
Aye.
Senator Mills. Aye. Senator Storm. Senator Thomas.
Aye.
Senator Wheeler.
Aye.
Senator Wilson.
Aye.
Chairman Wise.
Aye. By a vote of 9-0, the motion carries. Senator Thomas, sorry.
Mr. Chair, this is a highly legalized document. It's very legalized. And so I just throw this out for your determination. You are the chair. But I think this is the kind of document that needs to go on consent. I mean, I don't see any reason why it passed unanimously here, why we need to bring this to the floor for discussion. I just think because of the nature of the UCC and its update, and again, it's something that lawyers deal with. I think this is appropriate for consent.
I've not heard yet from Senate leadership on bills moving to consent calendar. I do agree with that. But I'm not for sure if today's the day, since I've not been told yet about consent calendar.
Nor have I, Chairman. That's up to you. I know they can take it off if they want to, but it's entirely your discretion, and I'm fine either way.
I think right now we just keep it the way it is and let it proceed through the process instead of putting it on consent. Now, Mr. Westerfield, I think you could handle it also on the floor admirably.
One section at a time.
Thank you so much. We do not have to go through that.
Is it too late to move for consent?
Mr. McGarvey, good to see you. Thank you for being here, sir. You're welcome. Next on the agenda is Senate Bill 144, an act related to the Kentucky Battlefield Preservation Fund. The bill's sponsor is Senator Rick Girdler. Senator Girdler, welcome. I know you're a member of this committee, but also as one bringing a bill forward. If you would, please identify yourself for the record and your guest, please. You may proceed.
I'm Rick Girdler from Somerset. I'm District 15, and I've got with me, he fought in World War I or Tom Bennett. We got a quick bill. You
Good.
can make it quick. It's not a bill that's going to take any money out of it. We're looking at revolutionary land they're going up. It's like supply and demand in America. If the gas goes to $1 a gallon, we're going to have a long line trying to get it. But if it goes to, the demand of it. So we got demand. We got two places left in Kentucky. We put down in our last bill dollar for dollar. We want to change the revolutionary side of it, $3 for $1. Like, for example, if we raise 100,000 private, then we want the state to be able to put 300,000 to buy that revolutionary land. Tom, you can add something?
We do need to first adopt the committee sub, if that's okay. Do we have a motion? I got a motion, Senator Wilson. I have a second from Senator Mills. All those in favor of accepting the sub, do so by saying aye. All those opposed, motion's adopted. Please proceed. We have a motion on the bill for Senator Mills. We have a second for Senator Wheeler. Sasha, please call the roll.
Senator Boswell. Aye. Senator Frankie Fromeyer. Aye. Senator Girdler.
Aye.
Senator Harper Angel. Senator Howell. Aye. Senator Mills. Aye. Senator Storm.
Consent.
Senator Thomas. Aye. Senator Wheeler.
Aye.
Senator Wilson. Aye. Chairman Wise.
Aye. By a vote of 9-0, the bill as it is amended passes. Thank you all so much.
Mr. Chair, again, since you're going to go to leadership and talk about consent, this is another.
I'm going to let Senator Girdler handle this on the floor, though. I think this may be good for his district and some of the things that he's got in that area. I think it'd be good for him to speak on.
If I don't screw it up.
You will not. I promise you that.
Thank you.
I'm going to let Vice Chair Wheeler assume the chair as I move down for the last two bills we have on the agenda.
There you go.
Chairman Wise, you may proceed, sir.
Thank you, Mr. Chairman. Members of the committee, Max Wise, State Senate District 16. What I have before you is Senate Bill 3, an act relating to the educator's liability insurance and making an appropriation therefore. Real briefly what the bill does. Senate Bill 3 establishes the Educator's Employment Liability Insurance Program within the Kentucky Department of Education. The program will provide excess liability insurance coverage to provide liability protection to teachers, including attorney's fees incurred in defending claims in the event that teachers are sued in connection with their employment within the schools. In this litigious society that we live in, teachers are faced with the prospect of being sued by parents of students. This excess liability charge will not protect a teacher from criminal conduct on their part. While the teachers may ultimately be found not liable in many cases, the cost of defending against the claims, particularly attorney's fees, can be substantial and in many cases financially devastating to the teacher and their families. This excess liability coverage will only activate if the claims exceed the underlying insurance coverage that the teacher should be covered by through their respective teachers association, which should make the excess liability coverage more affordable to the state than primary insurance coverage. The program is designed to assist in attracting new teachers and
Motion on
retaining
the bill.
existing teachers.
Second. Okay. All right. I have a motion from Senator Girdler, a second from Senator Howe. Madam Clerk, please call the roll.
Senator Boswell.
Aye.
Senator Funky Fromeyer.
Aye.
Senator Girdler.
Aye.
Senator Harper Angel. Senator Howell.
Aye.
Senator Mills. Senator Storm. Senator Thomas.
Aye.
Senator Wheeler.
Aye.
Senator Wilson.
Aye.
Chairman Wise.
Aye.
The bill shall pass with favorable expression. Vote was 9-0.
Thank you, Mr. Chairman.
Next up.
Senate Bill 169, if I would have Eric Kennedy, if he's still in the room, with the Kentucky School Board Association. If he would make his way to the table, please.
Yes, I'm Eric Kennedy, the Director of Advocacy for the Kentucky School Boards Association.
Senate Bill 169 before you is an act relating to public-private partnerships. And this was a piece of legislation that you had before you that I worked with Eric on when he was in his LRC role here before he left to work for the Kentucky School Board Association. I think it was in 2015, 2016, maybe in the time frame for that. We did not include in that original language local school districts of having the ability to partner into P3 projects. I'm going to allow Eric to discuss the importance of this as especially as it relates to school boards across the United States, or across the Commonwealth.
Certainly, thank you. Thank you and the committee for bringing this forward today. The bill was filed for several years and finally passed in 2016. At the time, there was a lot of discussion over letting local governments, primarily cities and counties, go into P3 projects for procurement of services, innovative financing, mostly construction of projects. School boards, I remember at the time where there was a choice to not put them in at the time. Since then, 7 years later, If anything, the constrained funding and now the cost of inflation and the constrained ability for school boards to undertake, especially construction projects, is an even bigger concern. Almost every day it's a bigger concern. So this bill would simply add them in and allow us as school boards to be treated just the same as cities and counties for P3s. All of the rules and processes and safeguards that are in place now for them would be there for us. On the first page of the bill, you see there's a provision already in the law that says not using a P3 can in no way get you out from under any substantive rule in any other statute or regulation. So all of the substantive rules about what boards can and can't do in connection with projects would still be there. This would be an innovative sort of delivery model for trying to get work done quickly that we need.
Motion on the bill. Okay. You may, Senator Thomas.
And do a lot, and do quite well. And of course, we've seen the constant increase in enrollment because of the benefits of it. I'm just sitting here thinking, how would that work on the local level? I mean, UK's used it for dormitories, for restaurants, for those kind of facilities that I can't conceptualize, and this is why I asked you this question. How would local school boards use P3 projects?
Yes, sir. Thank you. Especially in communities that are growing, as Fayette is, and especially in communities where the student enrollment is growing and available land at any price is constrained or the cost is going up. The biggest benefit would probably be in speeding everything up, so that you could contract with one private partner to do more aspects of the project of building, construction, and getting a building up and operating more quickly to ultimately save time and cost. I know Fayette County is working to open several new schools over the next few years ahead. They just recently opened a new elementary school. And so above and beyond, the most important piece of this, we think that would be a benefit, would be simplification and speed in getting something underway.
Briefly, sir.
Thank you. The way it benefits the private party, and I'll just use UK's example, is they receive dormitory rents, or they receive reduced rents in terms of the restaurants that locate in their facilities. So that's how the private contractor benefits, and despite what people may think, I'm all for private enterprise. I believe in the private enterprise, in the free enterprise system. But if you're talking about speeding up construction contracts, building new schools, how does the private employer benefit or profit in that regard? I mean, help me out here.
Another example to get more to what you've asked and zero in, there could be situations where either another local government could have property that they might want to go into like a property swap with. There could be cases, and we see this in also our largest school district in the state, where there is available property that a private business has that they would like to have in a complicated deal where one government agency has a piece of it, a private property is an adjoining property, and the school district wants to either buy or sell that for a new school. And having the P3 arrangement that it can simplify a very complicated project and get it underway more quickly, especially when there's more than one partner involved. So kind of putting properties together, piecing it together, several different revenue streams usually are the case with a school construction project. Having a P3 partnership to put all of that together would be a benefit than sort of the traditional delivery methods that a school board is facing with lots of steps in the process, and the traditional thinking of there's like one piece of land, I buy it from one party, and I do that as like step one, and then separately there's another piece of it that comes to design it. Separately there's another piece of construction. So we think that if it's totally optional, school boards may never use this, but if this passes and becomes law, we think probably the first place we would see it might be in some of our largest districts where complicated transactions of different owners and moving pieces are going to be all part of one deal.
I think we have a motion and a second. I think we had a motion from Senator Wilson and a second from Senator Mills. Is that correct? Okay. Madam Chair, please call the roll.
Senator Boswell,
I'd like to explain my yes vote. I do have some serious concerns about some sweetheart deals across the state involving the purchase of real estate for schools. Aye.
Senator Funky Fromeyer.
I'm an aye. Can I explain my vote?
May.
We are dealing with some very complex, your example is perfect. And we're dealing in Campbell County with some complex questions to this effect. And I also, like Senator Thomas, feel very inspired by local business and the opportunity for this P3 arrangement and reducing the complexity, but amplifying some business collaboration as well. So I think it's excellent. Thank you.
Senator Gardler.
Aye.
Senator Harper Angel. Senator Howell.
Aye.
Senator Mills.
I vote aye.
Senator Storm. Senator Thomas.
Aye.
Senator Wheeler.
Aye.
Senator Wilson.
Aye.
Chairman Wise.
Aye.
I believe that's all the business I have. I entertain a motion to adjourn. Motion adjourned.
Thank you, members.
Long day for you. No discussion.